Assalamualaikum dan salam sejahtera hadirin yang dihormati sekalian. Bagi memberkati majlis, kita mulakan dengan bacaan umum kitab Al-Fatihah. Amin, amin, ya Rabbal Alamin. Terima kasih diucapkan di atas kesudian anda untuk meluangkan masa bersama kami hari ini. Untuk maklumat semua, QR kod kehadiran bagi peserta UKM akan dipaparkan di akhir program ini. Seterusnya, saya ingin menjemput Profesor Madya Dr. Wan Muhammad Hirwani Wan Hussein, Pengarah Inovasi at UKM untuk memberikan ucapan alu-aluan. Dipersilakan.
Okay, Assalamualaikum dan terima kasih kepada pengurusi majlis dan Najwa. Jadi saya mengeluhkan Cik Rama and thank you for your time for having here. Jadi hari ini kita akan belajar lah dan saya pun berminat untuk belajar berkenaan dengan teknologi AI dan juga bagaimana Harta Intelek dapat membantu ataupun dapat melihat kepada isu-isu yang berkaitan dengan teknologi AI ni lah Dan kita juga melihat bahawa teknologi AI ini selalu banyak digunakan di universiti, Cik Rama. Jadi oleh pelajar-pelajar lah nak buat assignment. Jadi saya rasa mungkin ada soalan kot berkenaan how the ChatGPT membantu dalam assignment ke ataupun how we want to some sort of address lah teknologi AI untuk kaitan dengan harta intelek. Jadi saya juga mengucapkan terima kasih kepada partisipan dan peserta-peserta di atas talian. Ada sebanyak 113. Jadi memang berminatlah tajuk yang hangat dan harap semoga perkongsian daripada Encik Rama dapat diteruskan lagi lah di masa yang akan datang. Okey, sekian daripada saya. Terima kasih.
Terima kasih Doktor di atas ucapan itu tadi. Dunia semakin canggih kini. Pilihan terbaik tiada tandingi. Dengan AI, setiap langkah diawasi. Menjaga harta intelek, langkah berhati-hati. Bersama kita hari ini di dalam program Bicara Inovasi, siri yang ketiga bagi tahun 2024 yang bertajuk Teknologi AI dan Harta Intelek. Hari ini kita akan menjelajahi dunia yang semakin berkembang pesat, teknologi AI dan harta intelek. Teknologi AI telah menjadi pemacu utama dalam inovasi dalam pelbagai sektor, termasuk dalam pengurusan harta intelek. Dengan pemahaman yang lebih mendalam mengenai bagaimana AI dapat digunakan untuk melindungi, mengurus dan mengoptimalkan harta intelek, kita dapat membuka peluang baru yang luar biasa. Di dalam dunia yang semakin kompleks ini, perlindungan terhadap harta intelek adalah kritikal dan di sinilah peranan teknologi kecerdasan buatan menjadi semakin penting. Dengan kemampuan AI untuk menganalisis data besar-besaran dengan cepat dan memberikan pandangan yang mendalam, ia membantu dalam memantau dan melindungi harta intelek dengan lebih efisien. Jadi, kinilah tiba masanya dan saat yang dinanti-nantikan oleh kita semua, iaitu sesi perkongsian daripada penceramah yang hebat ini didatangkan khas untuk anda semua, iaitu Encik Ramakrishna Damodaran selaku pengarah urusan Adivent IP Sdn Bhd. Dipersilakan.
Terima kasih Cik Najwa, terima kasih, and thank you to Prof. Madya, Dr. Wan Hirwani Wan Hussein for the kind welcome. Good morning, ladies and gentlemen, and today our discussion will be on focusing on AI and IP. And first and all, I would like to wish belated Salam Aidil Fitri to everyone who are celebrating, and I'm sure you are having wonderful celebration with your loved ones. I think you're still within the celebration period, so it's still okay for me to wish Salam Aidil Fitri to everyone. Yep. All right. So now, as ladies and gentlemen, as you probably aware, in the last couple of days, the government has been organizing what we call a Scale 20, what we call program happening in KL as we speak now, and that actually involves a lot of parties, including the government, including the Prime Minister himself. All right. Cik Najwa, I'm trying to share screen, but I'm not able to share screen. Can you allow me to share screen? Okay, I think I should be able to share screen now. Yes. All right. So KL20 is actually a program organized by government in order to attract large technology companies to have their startup based in Malaysia. And by doing so, they are given a lot of new initiatives from hiring local talents to getting tax exemption and all the stuff. All right. And one of the technology focus area is AI. So AI is definitely one major topic that will going to change the way we do things. Like Prof. Madia, Dr. Wan mentioned just now, students use ChatGPT to prepare assignment. I can also tell you that ChatGPT can also be used by lecturers to check whether that assignment was done using ChatGPT. So ChatGPT, it actually works both ways. In fact, this is not something that I'm proud to say, but there was a case in the US just about last December, if I remember correctly. There was a case in the US, the lawyer prepared the argument using ChatGPT, the US lawyer, yeah, and he went to court and he discussed the court with the court using cases that do not exist at all. All right, ChatGPT hallucinated and gave him some cases that don't exist, and he was actually won by the court because he relied on ChatGPT to prepare arguments, and he was sent a warning letter and eventually barred by the bar council for using ChatGPT. So, right. So AI is something that actually happening as we speak, has already been happening for the last 15 years or so, but it is getting more and more prominent every day because we see new inventions coming up, and this is where the IP issue will be in the forefront. So today's topic will be looking at what AI is all about, what we can do with AI, and what kind of IP protection that you can claim if your invention is AI based. All right. So with that, I welcome you to my session on navigating the AI frontier in IP, where we're going to delve into the dynamic intersection of AI and IP. As Malaysia strives towards becoming a leading hub for IP, for innovation and technology adoption, understanding the implication of AI on IP is very important. AI in its various applications ranging from machine learning to natural language processing has revolutionized how we innovate, how we create, and how we protect intellectual property. In Malaysia, where innovation is cornerstone of economic growth, AI holds an immense promise for driving productivity, fostering creativity, and enhancing competitiveness. Throughout our discussion today, we'll be discussing about what is the impact on AI on various phases of IP, including patents, copyrights, trademarks, and beyond. We'll also be discussing the challenges and opportunities that arise that we're going to navigate into this landscape, and we will draw insight from the Malaysian initiative as well as the global trend to basically make our discussion more lively. Okay, but I hope at the end of the session, you will have a very comprehensive understanding about AI, about IP, and how both AI and IP meet, and what are the challenges you're going to face from the researcher's perspective, from the student's perspective, from lecturer's perspective. So whatever discussion that we're going to focus will be from the education sector perspective. Yeah. Now, let me show you some slides. I'm going to pause myself for a moment. Just have a look at these next few slides here, slides number 2 to number 4. You will see some of very interesting, what they call videos and photos that actually created by AI 100% without any human intervention. All right. I hope yes. So just this is a very short video. Just have a look. All right. So that's a very short video, as I said, created by AI. Let's look at the next slide here. Which one, just a very short discussion with all the audiences today. Can you let me know in the chat which photo you think is genuine, taken by a photographer, a human photographer, and which three other photos which are AI generated? Can I just see some comments in the chat, please? So this is number 1, number 2, number 3, number 4. 1, 2, 3, 4. So interesting, I see some answers coming in. I see people saying number 1. I see people say number 2. I see people say number 3, and I see people say number 4. Even within our group, right, we are not able to determine which is the genuine one and which is the what they call AI generated. I can tell you the original photo is actually number 4. Okay. If you can guess the answer number 4, you are very, very smart. You have a very solid eyesight. All right. Actually, number 1, number 2, these and number 3 were enhanced using AI. So a person like a senior person, lady, has been converted to a middle-aged lady into probably a youngster with a long hair. So he looks like a guy. Now, eventually, he looks like a very young boy. So this shows that AI getting smarter and smarter. Yeah. So you can see the quality of work is actually improving as we speak. Now, let's look at the other issue that we have also. All right. Now, this guy is a very famous TV host. So you probably have seen some deepfake videos. This is actually happening quite a bit, even in Malaysia. I think recently there was a celebrity filed a police complaint that there was a video about him, a deepfake video about him promoting a particular product when it was never endorsed or what they call endorsed or genuine video by that person. All right. So deepfake video can also be a big issue as we speak. Now, about 5-6 years ago, when I did a talk about AI in IP, I think with one of the universities, a lot of participants mentioned that, oh, while AI will take over jobs that will not involve creativity. For example, if it's a customer service, if it's teaching, all this can be taken over by AI. But works that involve creativity may not be affected. So people were not too worried about those who are involved in the creative industry were not too worried. But as you would have noticed from the 3 slides here, the video, the photo, and this particular deepfake video clearly mentioned that AI is actually going into the creative industry as well. So my point is that there is no one particular industry which is safe. Yes, as we are now, the AI systems are not perfect. So even if you remember the video that I showed on in my slide number 2, you would have noticed that the face expression was off. You would have noticed the translation was off. You would have noticed that the voice was a bit off. But remember, that video was taken a few years back. If you ask an AI system now to recreate the same video, say now or maybe in 5 years' time, I can tell you the quality will be much, much, much better than what we have seen just now. Remember, AI is about learning from the past mistake. So when people talk about the video, when people look at this photo and say that this is original, this is fake, the system captures your feedback and try to improve the output based on your impact. So that's why when Associate Prof. Dr. Wan mentioned about people using ChatGPT to do assignment, you will also be happy to hear from the lecturer's perspective. You will also be happy to hear that lecturers can use ChatGPT to see whether the assignment is actually copied from ChatGPT. All right. So ChatGPT is also getting smarter. Of course, ChatGPT is not the only one out there. You have Bard, you have so many other generative AI systems out there. What is important now is people must understand that all these are machine created output. So the quality will never be 100% accurate. So while we should be encouraging people to use all these available technologies to improve their output, students must understand that copying something from ChatGPT or any generative AI for the matter, it is not something good because it's plagiarism. It is actually illegal. And there was an incident in India, I think last December also. The student was found to copy and he was barred from the examination. Okay, so very important that you need to look at what are the possible pros and cons of AI. Now, let's because our focus today is AI and IP, I also must share with you what are the types of IP. I have now about 140 participants in the discussion today. Let's make this as a discussion, yeah, rather than a lecture. I hope all of you can actually put a comment in the chat. How many of you have filed IP application? It can be patents, it can be copyright, it can be trademark or design or any other IP. Or you are aware of all these IP, like people from Inovasi, they will know what are the IP rights. But from the researcher's perspective, from the student perspective, I would like to know whether you are aware of all these IP rights and how much do you know? So can you put a score like between 1 to 10? Where do you rank yourself? 1 being very little, 10 being you are perfect, and so that I don't have to spend too much time if almost all of you say 10. Can I take like 2 minutes for you to answer? Okay, I see someone says 1. 4, 3, 2, 2, 5, 6. Very good. How about others? 5, 4. Good. 6, 4. Okay, so I see that majority of you have given between 2 to 4. So let's, in that case, let me run through what are the IP rights so that will give you some idea what are the things that you should be looking at, right? Now, when we talk about patent, patent actually is filed to protect technologies. For example, if you have an invention, say, for example, just now I was looking at the video from Inovasi, she mentioned about the drink and also the composition and what is the health benefit. That will be the technology, all right? So the composition is a technology. The process of making the drink is technology. The way you bottle the drink is a technology. The way you consume the drink is technology. All right. So all that will fall under the patent protection. Now, when we talk about copyright, I think most of you in the education sector will probably understand copyright, because copyright is actually something that is original. If you prepare a PowerPoint presentation like what I have prepared today, or if you have prepared a paper, if you have prepared drawings, if that PowerPoint presentation, if that drawing, if that paper, the contents of which are original, okay, you have the copyright over that particular work. Remember, the keyword is original. That means if you copy from ChatGPT, it is not original. It is not your work. Therefore, it is not your copyright. All right. Now, trademarks also probably most of you will be familiar, because I think every one of you is every one of us is a consumer. We buy products, we buy services from time to time, in fact, every day. For example, UKM, the brand is actually a trademark. Okay, and I have about 140 participants today. Each one of you has your own name. Your names are your trademark. This is how people identify you. This is how people relate you to a particular product or service. For example, if let's say I take Cik Izaida Isha, she's from Inovasi. So we have been dealing with Cik Izaida for about 12 years now in UKM. Now, if anybody who knows Cik Izaida, they always probably relate Cik Izaida to IP, okay, to commercialization. But they may not associate Cik Izaida to say to, for example, to teaching, because she's not a lecturer, right? So now, can you relate Izaida, the name Izaida, to IP? If so, that becomes her trademark. If Cik Izaida is not teaching, then people don't associate her to teaching. Therefore, Izaida and teaching don't fall as a trademark. Okay, I'll go through that in a bit later. Industrial design, normally you're looking at, for example, shape of products. Like, for example, I'm sure all of you are looking at in front of a laptop, looking through your phone. The shape of your laptop, the shape of your phone, the shape of the cup that you use to drink coffee, all that will fall under industrial design. But also must remember, yeah, IP rights are not limited to these four. While these are the more famous one, of course, there are probably hundreds of different types of IP. For example, trade secret. When I ask almost all of my audiences what is the famous trade secret, everybody talks about KFC, the secret herbs, the secret ingredients. They talk about Coca-Cola's formulation being trade secret. They always focus on the food item. But you must remember, yeah, even your customer database, even your partner database is actually what you call confidential information trade secret. So the question that you need to ask yourself is that you have your, let's say if you look at your phone book, you have say 100 contacts in your phone book. Can you share your phone book details, like the phone numbers, with third parties without the permission of the people in your phone book? The answer is definitely no, because people shared the number with you because they wanted to discuss with you, they wanted to chat with you, they wanted to talk to you. They are not giving you the phone number so that you can pass the phone number to other parties without their permission. All right. So phone number, email address, even photos are actually something to do with your IP. Now, people always ask me, in that case, how does social media works? Okay, because social media, the moment you sign up for a social media page, I'm not talking about any particular social media particularly, I'm talking about generally. When you talk about social media, one of the things that people must remember, when you sign up, there will be a long agreement, and I can tell you 99.99% of people don't read the agreement. Okay, because they just want to sign up because everybody is in on social media, therefore I also must be in social media. Now the question now is, if I post a photo or video on a social media, can the social media platforms use that photo and use that video? Can I see some answers in the chat? The question that I'm posting to you is that you post a photo on your social media, you post a video on your social media, you post a quote on your social media. Can the social media platform share that without your permission, or you must give the permission? Just put Y or N, yes or no. Can I see some answers, please? Yes, yes, yes. Okay, so the answer is yes. So the question that I need to ask you is, will that be considered to be an infringement of your rights, because that's your photo, that's your video, that's your code? Can you sue the social media platform for using that photo, video, or code? Can I see some answers? Y for yes and for no. Can you sue the social media for using your material? No, no, no. Why you think the answer is no? The answer is definitely no, yeah? So you definitely cannot sue them, okay? But the question that I'd like to ask you is, if I say that copyright is something like original work, like your photo, your video, that's your copyright, right? But the moment you post it on social media, you are losing the copyright. The reason is when you sign up the agreement, one of the clauses, if you read very carefully, one of the clauses is that the social media platforms will demand that the moment you put the photo or video or code on your social media, you have given explicit rights to the platform, to the social media platforms, to use your material, and they are not liable. Okay, so that means you are giving away your copyright to these platforms. Now, in that case, the answer is you don't have copyright on the photos that you post on a social media platform. Now, can I take your photo and put in my social media page and say that Cik Izaida doing pattern? Okay, just that, yeah. I'm not saying anything bad. So if I say anything bad, that's a different issue altogether. That is defamation. I'm not going to talk about that. My issue is that I'm saying something true about Cik Izaida, that she's doing pattern, she's doing IP, she's doing trademark. But am I allowed to use the photo that has been posted by Cik Izaida on her social media? The answer is no. Remember, you are giving permission to the platforms, not to the users of the platform. Okay, so all this something that you must remember. There's no like a black and white. This is what people can do and this is what people cannot do. There are many things that you can do. There are many things that you cannot do, and that's why it's very, very important to have a clear picture on what you can do and what you cannot do. Yeah. So remember, we only have about 1.5 hours to 1 hour 45 minutes to discuss. So I'm not going to go into details of each areas of IP. That will be a totally different subject altogether. But there, I think I've given you a very broad perspective about IP, the major types of IP: patents, trademarks, copyright, and industrial design. Let's look at this graph. Yeah. Of course, this is not a very latest one. We don't get the latest info. But if you notice, from the year 2017 to 2018, they were like the one in orange color is a patent file in AI domain. They were only about 660 patents filed in the AI domain. But fast forward to 2021, 2022, there were 4,063 patents filed in the AI domain. Now, this statistic, I got it from Lexology, and this is actually the data from India. Yeah, I don't have the data from other countries. Now, if you see here, the percentage has been going up. The number of patents, overall patents, have been going up also, even at the peak of COVID. You see, COVID started in 2020, 2021, 2022. I think we came to the end of COVID pandemic in 2022. See, the number actually almost double when it comes to AI. But in terms of overall patent filing, the number wasn't really double. So now, why I'm trying to say this is that the number of patents filed on AI technologies actually has been increasing every day. Every country that I have looked at, the data actually has shown significant increase in AI. Why I'm using India as a case study here is because India, for obvious reason, they have a very good IT system in place, and they have been doing that for the last 50 years now, I think. So they actually in the forefront when it comes to AI. But the major AI technology companies are actually based in countries that you usually suspect, the likes of US, in Europe, in China, in Japan. So definitely the number has been increasing overall. Now, the question that you need to ask yourself is, where do Malaysia stand in relation to this? And more importantly, where do UKM stand in relation to this? Now, can I put in the chat, again, question for you guys, you can answer in chat. How many of you have filed patents, how many of you are actually working on AI technologies or creating AI technologies? Can I just can you put answer like me, or those who are not involved, doesn't matter really. I just want to see how many of you are doing AI technologies. So far, I don't see any answer. So I can assume that most of you are not doing AI technology, or maybe still in the very early stage. Okay, I see someone put in the chat. Yes, correct. Encik Harid, yes, working as in research using AI, or you already develop AI solution, or we are in the industry, from the industry, you are already using AI solutions to do something to do with your work. So Encik Supaya said early stage, understand? All right. So clearly shows that AI is actually at a very early stage in Malaysia. That's actually something that we have to accept. Even universities are struggling to understand AI, because AI, you must understand here. No, if you ask anybody who is doing AI, is an AI practitioner, if you ask them what AI can do, nobody can tell you the answer. People know very well that AI can do many things. What they actually can do, nobody can guarantee you. All right. The reason is it's a very open-ended spectrum. Okay. You can train the machine to do, for example, let's say you are dispensing drugs to a patient. Let's say that patient is bedridden, and there's no caretaker for that patient. You need the machine, the robot, for example, to provide the medicine like every 6 hours, every 8 hours, and making sure that the patient is hydrated and clean and all that. All right. Of course, we have like what we call the nurse robots. Now the question now is, can the nurse robot today, who is actually providing medicine to the patient, be trained to carry the patient if that patient is bedridden? Possible. If I ask you, can the nurse robot be trained to become a doctor? The answer is possible, because it is, end of the day, you don't have a proper definition about AI and what are the things that AI can do. Hence the reason why Malaysia actually setting up this KL20 program that happening from yesterday until tomorrow. One of the things that they are looking is actually to come up with a proper definition of AI. In fact, there is already a secretariat now established at the ministry level to govern all AI practices in Malaysia. So we will see quite a bit of changes happening in the Malaysian arena in the next 2 to 5 years, where we'll see more and more AI technologies coming in, more particularly from the semiconductor industry, because I think the government is actually pushing for the semiconductor industry to be in the forefront. Right? So definitely, I'm confident that we will see more patents be filed by Malaysian companies, universities in this domain. Now, look at this. Can invention created by AI be patented? Okay. Just now, I think one of the person in the chat mentioned that. Let me go back. Sorry. I think one of the participants mentioned that he's working with AI. Now, if you have come up with an invention created by AI, can that be patented? I think Encik Arid, yes. Encik Arid said that he's working with AI, right? So Encik Arid, if you can unmute yourself, or if you can answer in the chat also, have you used AI to create new invention? Okay. Now, let's say one of the participants today is a lecturer, and he or she is using AI to create invention. The question is, can UKM claim a patent protection for that particular technology? So the question that I'm raising is that, can technology created by AI be registered under the patent protection? So the Encik Firdaus, I'll come back to your question in a bit. Yeah. So the one is a general discussion. I'll come back to your question. I take note of your question first. All right. Now look at the diagram on the right hand side of your screen. These two inventions were created. I'm sure some of you may be familiar with this. These two inventions were created by AI called DBUS. DBUS is actually a machine learning system that actually trained by this guy called Steven Tyler. Steven Tyler, what he did was he created the AI machine. The AI machine created these two inventions. Nothing fancy about this invention, very basic stuff. It's a container, by the way. And this is actually the structure that actually being used to come out with this container. It's a bottle, all right? So nothing unusual, nothing great, but it was created by AI 100%. Now the question, what happened was, Dr. Steven Tyler filed patents in a number of countries claiming these inventions, these two inventions. Okay, but one thing he did was, which never been done before, that he named DBUS, D-A-B-U-S, as the inventor. Because according to him, Dr. Tyler, he invented the machine. The machine created, the machine as in my case, DBUS, the machine is the one who created these two inventions. Therefore, it is not right for him to claim to be the inventor. All right. So the patent was filed in many countries: US, Europe, South Africa, Australia, UK. All right. So one of the first conditions for those who have filed patents is that under the current definition, an inventor must be human being. Okay. Because remember, the law was created about 200 years ago. In Malaysia, the patent law was enforced in 1989. Back then, AI wasn't really a famous term. So people were not aware of AI. People never thought we will come to this situation where AI going to create new inventions. So the definition of inventors under the patent law worldwide is it must be human being. Because of that, DBUS patent was rejected in all the countries. Even when the matters went to court, the court held the decision of the patent officers to be valid. In most countries, I use the word most, I'll explain why. In most countries, the patent applications were rejected, not because the invention was not patentable, but because the invention was invented by machine. And because it is not a human being, technically the patent, one of the first requirement of patent was not complied with. So whether you agree with that decision or not, I leave it to you. But what I'm trying to say is that this is what most of the countries decided upon. However, just for info, back in 2021, that case went in the South African court. And surprisingly, okay, sorry, maybe I should once mention one more thing. Just before South Africa, the matter went to Australian court. The the federal court declared that a patent invented by machine can be patented. That means the inventor can be a machine. However, a few months later, that decision was overturned by the High Court in Australia. Now, the decision is status quo. In Australia, the inventor must be a human being. However, fast forward for the first decision from Australia, South Africa court decided that machine can be an inventor, similar to what they had decided in Australia, in the first court, in Australia. And that decision in South Africa has not been overturned. So, in most countries around the world, inventions created by machine cannot be patented. Invention in South Africa, inventions created by AI, as we are now, as at this point of time, can be patented, subject to any decision by the courts who may overturn the decision may happen. Now, the question that I need to ask you is that if your invention is created by AI in Malaysia, can you answer in the chat whether you think the patent will be granted or rejected? Granted like South Africa or rejected like rest of the world? Just put Y for yes and for no in the chat, yeah? No, no. No. Okay. Thank you for those who answered. For me, most likely the answer will be no. Why I use the term most likely because we don't have any decision from the court as of now, Malaysian court as of now. But Malaysian courts tend to follow the UK precedents very closely. And because the UK court in Debus case rejected the patent on that specific ground that inventor must be human being, I assume that the Malaysian courts will follow suit. So in that case, the patent will not be granted if you name a human being. So to avoid that, my recommendation to you guys who are working on AI, and if your AI creating new invention, please name yourself. Again, I probably will agree with you if you say that's not ethical. That's true. But if you don't name yourself or any one of your colleagues as inventors, you cannot, first of all, your patent will not even go through the first stage. All right. So something for you to think about. Now, let's say we do, if you really decided to file a patent, then technically you need to see whether the patent is that kind of invention has been invented before you. So what we can do is that we can actually conduct patentability research to see whether your invention, whether created by AI or by yourself, is patentable or otherwise. Now, speaking about patentability research, all this while, most firms are using the patent attorneys to conduct the search and give you the opinion. But a lot of IP firms have now started using systems, AI-enabled systems, to come up with a search and to give the opinion. So eventually, the opinion will be still signed off by the patent attorney. But my point is that the patent attorneys are getting help from this kind of AI-enabled system that will actually increase the quality of the report. Because human, there's so much you can do. Machine, there are much more than what humans can do. All right, search can be done. Also, on the other hand, you also want to see whether your invention can be sold in the market. When you talk about patent infringement search, means that you have invented an invention, whether it's patentable or not, that's a different issue altogether. But you say that I want to sell this product. For example, this particular bottle from Debus, if Dr. Tyler said that I want to sell this bottle, he needs to do what we call as a patent infringement search to see whether that particular product can be an infringement of third-party right in a particular market. Okay, just like patentability research, patent attorneys also relying on AI enabled system to do patent infringement opinion search and opinion. All right, so things are getting very exciting in this field, especially in the patent field, where we talk about how patents can be granted or not granted, whether you are you need to do search or you don't have to do search. Okay, now this is the case that I mentioned involving Debus just now. So to give you like a overall picture what happened here. So if you can see here, the inventor that I marked here as in blue, you can see clearly that Debus was named as the inventor and Dr. Stephen Taylor was named as the owner of the patent. Applicant here refers to the owner here. So this patent made headline worldwide. So if you can see here, this is from the US. The top decisions are actually from the US. You can see that the status here is application is denied. Okay. Now, this is the European Patent Office. EPO stands for the European Patent Office. They also rejected the patent because you can see the third line here. I don't know whether you can see clearly from your screen. He clearly says that artificial intelligence named Debus as the sole inventor. So remember, the only ground for rejection was because the inventor is not a human being. So this is US and this is European Patent Office. So similar decision, this is Australia. So as I mentioned just now, the first court at the federal court said that Debus may be named as inventor. This happened in 2021, July 2021, right? But eventually that decision was overturned by the High Court. Now the court said that AI is incapable of being an inventor. So it's still going back to human. But South Africa said possible. So they became the only country, or the first and the only country, actually recognizes AI to be an inventor. All right. Now, from your perspective, I would like to know from you, maybe in the chat now, if you are a researcher, if you invented a machine and that machine created an invention. Now, from your perspective, would you claim to be the inventor? Yeah, can you please just put yes or no? Remember, you are Dr. Stephen Taylor. You invented labels and you filed the patent application. Will you claim yourself to be the inventor? Can you just put some answers in the chat? So File said no. No. Umi said yes. Yes. For those who said no, I can understand just now, like mentioned, is like a more on the ethical issue, because you are not the one who invented the end product. I totally agree. But as I said earlier, without naming a human being, whether you or your colleagues, you are actually eliminating the issue of getting a patent. You will face in the first round itself, fail in the first round itself. So it is something like a policy that UKM supposed to take. If you're working on AI and AI created something, UKM Inovasi department should come up with a policy. What is your what do you call outcome? Like UKM say that, okay, whoever invented the machine can be named as inventor. Whether the inventors agree or not, that's a different issue altogether. But if the policy or the guideline by UKM says that human beings should be named, failing which will not be able to get the patent, then UKM, I believe, should come up with such a policy and guideline so that people doing research in your university will know where they stand. Or on the worst case scenario, UKM says that if the invention is created by a machine, inventors should be the machine, and therefore we will not file patent. We will not name anyone just for the sake of filing a patent application. That is also something I'd be happy to accept. But remember, that kind of guideline must be given. Failing which, your researchers will have a very difficult position. They will work hard to create something, and then UKM says, no, that's not possible. Or UKM says that's possible, but get rejected by the patent office or the court. Yeah. So at this point of time, I'm going to take some comments here. I think let's see. Yes, Encik Firdaus mentioned, he said that to me, maybe it's like Google that can give you the most answers I ask. Maybe AI will give you a better or more dangerous if not controlled. That is absolutely true. Google is also enabled by AI. So you must remember that. And Google has been working on AI for longest time. A lot of people actually think that AI is something like a very brand new thing. Actually, it's not. The term artificial intelligence was coined in about 60 years ago. So about in 1950 or something, yeah, I can't remember the exact year. So the word AI was first coined in that era. So AI has been there for almost 50 to 60 years now. Now, you must understand the reason why it became very popular in the last, say, 10 years or so is because of the 4G, 5G telco system that we have now. Because under the old 2G, 3G system, many things were not able to be created because the internet speed and the amount of data that was available was pretty much very limited. But now under 4G, 5G spectrums, now the data processing becoming faster, the storage becoming faster. So people are getting more excited and more research work is being done by AI. So of course, I agree, Firdaus, it is dangerous if you not control it. That is the reason why we have to have a proper guideline definition about AI. AI, if you use it properly, it is a good thing. If you use it badly or you develop it and train it to be a bad thing, definitely it's a bad thing. It's just like a child, yeah? If you bring up your child in a very good manners, of course, that child will grow and become a very good person, okay, quote unquote. But similarly, if you train the machine to be a bad machine, obviously the output will be dangerous too. So it is important to have a good AI governance system to avoid this kind of a situation eventually. Yeah. I think there's one more comment before I move on. Yeah. Cik Umi said, as long as there's a human intervention, there's no need to name the AI as inventor. The same way technicians are usually not named as a co-inventor in patent application. All right. This I probably, Cik Umi, I probably have to disagree with you with all. Just let me explain why. Because in the case of DBUS, right, the human intervention was involved at the time of creation of DBUS, meaning Dr. Tyler created DBUS. So the human intervention stopped there. But when DBUS, what DBUS did was, it created these two inventions. So at that point of time, human intervention was pretty much zero. So DBUS patent was filed on that basis. All right. So now why I say I tend to disagree with you is because we do recommend to our clients to name technicians as co-inventors. We do recommend, yeah, if they have contributed to the invention from the technical perspective. Remember, the definition of inventor is that that person must have contributed to the invention from the technical perspective. Let's say, for example, if you say that you come up with this particular bottle and you ask your technician to do like a stress test on the bottle to see whether that can withstand multiple factors, like, for example, heat or chemical attack or whatever it is, right? So the technician conducts the experiment based on your requirement. He comes up and gives you the result. He's not a co-inventor because he is reporting the findings of the experiment. But let's say you created this bottle and you ask the technician to do a stress test, and the technician comes back and tells you, sorry, Prof, I did the stress test. I applied so much of pressure on the bottle. After so much pressure applied, the bottle collapses. But when I use a different material, for example, you use material A, I use A plus B. I added a bit of B into the bottle. Now, the result looks more promising. That means when I apply the same amount of pressure, the bottle doesn't collapse. For example, yeah, this is just a purely discussion purposes. In that case, the technician has contributed to the invention, and therefore you should name him as a co-inventor. All right. So whether he's involved or not, depending on what you file. Let's say you file only the original material A, then technically you don't have to name the technician. But if you claim A and then you say that alternatively I can also do A plus B, then the technician should be named as a co-inventor. I hope I clarified that that comment. All right. Then yes, Shufal said before AI became popular, Google search engine is also popular, also on AI. You have any answer, ask any question with a specific keyword, you get the answer. But what is different between a search engine and an AI platform is that you must understand that AI is actually comes with additional intelligence. For example, if let's say about 15 years ago, if I ask Google, what is the weather in Bangi today? Okay, Google will say, oh, it's 25 degrees or 30 degrees now. But if you ask Google today, what is the weather in Bangi? The Google search engine will learn the intent behind my question. Meaning, the system will then look into my past history, my historical search keywords and all that, to try to figure out why Rama is asking this question. Is it because he's traveling to Bangi? Or is it because something happening in Bangi that he has to go there immediately? Or whatever intent it may be. So what will happen then is that the search engine now not only will answer you the weather is the temperature is 30 degrees in Bangi, it also will tell you that if you are taking Grab, you will reach there in 25 minutes. If you are taking the train, it will take you 1 hour, but don't take the LRT because the LRT broke down. So you are getting more than what you expect. That intent may or may not be accurate, yeah, okay? But the point I'm trying to say is that if you ignore that explanation about the transport, then the search engine will learn you are more interested about the weather rather than going there, you know. So that will actually give you a different perspective. So that's the difference between purely a search engine versus an AI-enabled search engine. Google definitely is AI-enabled. A lot of search engines are already AI-enabled. Okay, now let's look into other areas of IP. During my first part of my discussion, I mentioned about the original work. If you are doing anything original, it is copyrightable. Now, I'm sure all of you are familiar with DALL-E, the search engine, sorry, not search engine, the platform that is used under OpenAI, ChatGPT, the founder of ChatGPT, to create images. This image that you can see on the right-hand side here is actually developed using DALL-E. You're probably also familiar with Canva. Okay, my daughter, she's 12. She doesn't like to use PowerPoint. She thinks that PowerPoint is outdated. Okay, she said that who uses PowerPoint? Everybody uses ChatGPT. I'm a very old school. I still use PowerPoint. Now, the question that you need to ask you is that if the ChatGPT created that image, that video that I showed you at the beginning, or that photo, who's the author? Definitely you're not the author, yeah? So technically you cannot, just like patent, you cannot claim you are the author. And just like patent, under the copyright law, authors must be human beings. Okay, now, the other thing that you also must remember, patents are valid for 20 years maximum from the date of filing. But copyright is slightly different. It is actually, in Malaysia, is lifelong of the author plus 50 years. For example, if I created this PowerPoint yesterday, for example, and so yesterday was 22nd of April, and let's say I die, say tomorrow, 24th of April 2024, okay, my PowerPoint, the copyright to my PowerPoint will be the 2 days between 22nd to 24th, where I was alive, plus another 50 after I die. That means my copyright protection will be until 2074. In the US, it's plus 75. Now, the reason why I'm highlighting is that this is also another issue about AI, because AI machines cannot die. You know, so how you determine term of copyright? So that is why I only highlight to you that authors must be human. Term of the copyright also forces the definition to be human. Therefore, at this point of time, anything that you create using AI machine, it is not copyrightable. A lot of people say copyright means is right to copy. That is absolutely wrong. Okay, copyright means is right not to copy. Okay, in other words, if I have copyright, I'm claiming ownership of that copyright, and you are not allowed to copy, because people like to see right and the word copy, and then they treat that together and they say, oh, copyright means I'm free to copy. The answer is no. Yeah, there's also thing called copyleft. Okay, remember copyright, copyleft. Copyright, as I said earlier, does not allow you to copy. Copyleft, on the other hand, allows you to copy. Copyleft is not something that is available in the law or by any definition of the law. Yeah, no. Okay, copyleft is a term coined by this kind of open source creators, where they say that we are not creating anything that is claiming that we are claiming ourselves. We are putting this in the public domain so that people can copy. So the term copyleft is something that you, as I said, doesn't exist in the law, in the act, but it's actually a term loosely used to say that you are free to copy. Open source is one form of copyleft. On the other hand, there are so many generative AI. So this is what you need to be very careful. If you use ChatGPT, if you use DALL-E, if you use Deepfake, if you use Canva, for example, all this work will not be copyrightable or claimable by you. Okay, so please take note if you are using the machine. Of course, I'm pretty sure everyone will be using the machine. If you haven't started using, you will definitely be using it. So bottom line is, it's not your right. So at this point, I'm going to take some questions here. Copy left, not copy left. Yeah, copy left. Yeah, correct. Okay. Okay. Now, copyright and AI cases. Now, in Malaysia, I'm sure some of you are familiar that we have this thing called fair dealing. Okay. Fair dealing, in other words, means that there are certain permission given by the law for you to use copyrighted material for research purposes, private study purposes, criticism, review, reporting of news, current news, and all that. For example, let's say you publish a paper. Okay, I'm using the paper to criticize, for example, you, or to comment on your work. That is actually a fair dealing allowed under the Copyright Act in Malaysia. Okay, memes. I'm sure a lot of you watch memes on your social media, on your WhatsApp, for example. The memes will fall under criticism or review or reporting news, however it is, right? Now, in the US, they use the term fair use. Okay. Now, the thing in the difference between fair dealing in Malaysia or UK, fair dealing, fair practice is actually a UK, Malaysia definition. Fair use in the US means it is also for research, private study, the same definition, but the law in US copyright statute says that it's merely illustrative, meaning it's not limited to these 5, 6 things. Okay, so in the US, you have more opportunities to copy third-party copyrighted material. In Malaysia, in the UK, or I would say, I'm confident to say, most of the countries around the world will have fair dealing. Now, let's look at this case that is happening, started last January, if I remember correctly. The New York Times sued OpenAI and Microsoft. So some of you actually would have read about this news. Apparently, I don't know because I seldom read New York Times. Apparently, New York Times has certain way of writing. Their authors, their journalists are trained to write using certain criteria, certain way that apparently is unique to New York Times. Okay, how? Because I don't know the details yet because the matter hasn't really been tried in the court yet. It's just a very fresh case. So they said that they have a very unique way of writing. And OpenAI, which is the company behind ChatGPT, and obviously Microsoft Bard, New York Times claimed that that machine had been trained using New York Times data. So the answers given by ChatGPT and Bard resemble the answer how a journalist in New York Times or an author in New York Times will give the answer. This is a very interesting case that is happening. I'm looking forward to the decision how the court's going to look at this, because this will be a very like a prominent test case for the rest of the world. That is what New York Times claimed, that they have a unique way, and these two generative AI followed the same method of writing. But OpenAI and Microsoft, in their defense, filed their defense by saying that, see, we are reporting news. We are reporting current events that is happening. We are enhancing the knowledge of the readers. So therefore, our response, our answers will fall under the fair use definition in the US. Therefore, New York Times cannot sue them for copyright infringement. So this is a very interesting case. We will keep you posted with the development with this case. It's not going to complete anytime soon. I'm sure it will take at least 1 year for us to hear from the first court and subject to appeal. So until we get the final conclusion, it may take about 3 years before we get the final conclusion. Yeah? Okay, AI and trademark. Okay, look at this diagram. So trademark, as you probably know, is a brand. Like I mentioned, UKM, your name, all that is a trademark. You see some of these brands. These are very famous brands: Chanel, Adidas, Louis Vuitton, Nike. All these are very famous brands. They have been there in the market for decades. Now, when we use generative AI to design logos. Generative AI are creating this type of logos. You can see Chanel with all these things dropping, Adidas, all these things, right? Now the question now is, can this trademark be registered? I told you patent not registerable because inventor is not human being. Copyright not registerable because the author is not a human being. But trademark, I can tell you, the law does not need you to declare who designed the logo or the trademark. Therefore, any AI-generated trademark should be registerable, subject to it complying with the rest of the requirement. Like, for example, it is not a copy of a trademark. For example, if you ask me whether this Chanel will be registerable, the answer is no, because it is very similar to Chanel. But if let's say Chanel is famous for fashion items like handbags and whatnot, right? If let's say I come up with a pen, maybe pen is a bad example. Let's say light, okay? I call it Chanel and I use this logo. I probably can get away with it because Chanel, the company and the brand, is very famous from fashion perspective, but they are not known from the lighting perspective. So my point is that there's always a chance that this particular Chanel probably can be registered for different products or different services that Chanel, the company, is not doing at this point of time. That applies to Adidas or Louis Vuitton or Nike. Yeah? So similar to patents and copyright just now, you still have to do a search to see whether that trademark can be registered. You need to do whether, like patent, there's an infringement search, we call trademark clearance search, again to see whether your product, your services bearing that particular logo can be sold or offered in that particular country. All right. Just because you're free to sell a product in using Chanel for lighting purposes in Malaysia does not mean that you can sell the same product with the brand Chanel for lighting in Singapore, because Singapore, the trademark laws may be different from what we have in Malaysia. Okay. Or the company in Malaysia, let's say Chanel, claim only fashion items, but in Singapore, for whatever reason, they claim lighting. Okay. Therefore, you may be able to sell in Malaysia, but it will be barred from selling in Singapore, or vice versa. All right. So keep that in mind, that there's no such thing as a worldwide clearance, or just because your trademark is registerable in one country doesn't mean it's not registerable in the rest of the world. No, yeah. Okay. At this point, maybe I can take some question from the chat. Okay. Umi said, but there are images AI generated sites that said that the TOS, that images generated by the site cannot be protected. That is the agreement between you and the platform, yeah, Cik Umi. This one we need to be very clear. While, okay, the question that, yeah, I totally agree with you. The terms and condition of the generative AI normally will dictate that you cannot use that because that is not your copyright. The system created it. I totally agree. But what happens if you do file the application nevertheless? You go ahead and file this Chanel application for this particular trademark and you proceeded to file. Most likely the trademark office definitely they won't know that this was created by AI, because you don't have to declare as such. Okay. So when the trademark office does not know that this was created by AI, okay, they will process this application as if the logo was created by a human being. And subject to it complying all the rules, the trademark should be accepted. But if, let's say, I, a third party, you created the logo using AI generative, Umi, I'm a third party, I see that, oh, I know that mark was created by AI generative site, okay? I need to go to court to sue you to get the trademark revoked. I need to submit evidence. So it's not going to be a straightforward process that just because the agreement with the AI generative sites dictate that you cannot claim. But even if you claim, it is only, the trademark will only be rejected if somebody challenges you at the court of law. Okay, and that's not a straightforward process here. It's costly, it's time consuming, so on and so forth. Okay, so I hope I answered that question. Okay, yes, of course, McCurry McDonald's is a very old case, but it is not really a very, it's not involved in the AI domain, so I'm going to bypass that. But I will share with you at the end during our Q&A. Yeah? I'll come back to your question about in later. Okay, now industrial design. Remember, industrial design is about the shape of the product, the 3D version of the product. It's not the technology, but rather the shape. Would you like this kind of glasses? Okay. For me, it looks interesting, looks unique, looks different from what we see in the market now. Maybe they are already in the market, I don't know. But again, the question now is, you created a 3D product, the shape comes up very interestingly, and so happened the design was designed by your AI generative platforms or your own AI that you created. The question now is, just like pattern, can I register a design? The answer is no. Because industrial design also requires you, the law requires you to name the designer. I use different terms here. For patent is the inventor, the term is inventor. For copyright is author. For design is designer. So it's the same thing, yeah. So again, the answer, going with the decision with diverse, okay. I would imagine design created by AI will not be registerable, okay. Similar to patents and trademark search, you also need to do search to determine whether you are, if you want to claim yourself to be the designer, you need to do a search to see whether people have done this kind of design before. Also, if you are selling, you need to do a design search. You can also use many AI platforms to do this kind of searches here, whether it's registrability or infringement. Okay, now let's now it's already 11:15, so I have another 45 minutes. So we are in the last part of our discussion. This is on the more on the legal and ethical side. Now, this is a very important aspect for you to consider. Do you want to consider the legal consideration or do you want to consider the ethical consideration? Being a researcher, you always have this conflict. I don't want to name myself as the inventor because I'm not the inventor, Debus was, okay? It's an ethical issue. But you need to look from the legal perspective. If you don't put your name, okay, you won't get the patent. You're going to lose your KPI. You can probably, the management will come back to you and say that, guys, we have spent so much for the past 5 years and I don't see any patent filed by your department. What happened? Okay, so you're going to have that issue sooner or later. Yeah, so this is going to be the part where we're going to discuss from your perspective what you really have to worry about. Now, look at this slide. If you created, sorry, if an AI machine created an invention and you claim a patent, okay, let's say in South Africa, okay, for argument's sake, because they have this position now. In South Africa, I told you just now, inventors can be human, can be machine. Therefore, technically, Debus patent is valid. Now, who has the right to sue? Remember, the South African patent is clearer because Dr. Stephen Taylor was named as the owner of the patent. Therefore, Dr. Taylor can sue third parties if they copy. What happens if Debus was named as the inventor and Debus was named as the owner? Can machine sue others? If they can sue, they also must remember that they can be sued. Can human or another machine sue a machine in court? So who's the plaintiff? Who's going to pay the lawyers? Who's going to come to the court and give comments? Who can be, what they call that, questioned by the lawyers? Who's going to be guided by the judges? So these are the things that you must remember. If you say that AI should be the owner, then AI should have the rights to sue. And therefore, they should have the rights to be sued. At this point of time, the position is not possible. Maybe in the 30 years time from now, things may be different. I don't know. Okay, that's why I said being an IP and AI practitioner, because I also run an AI firm, so I know what is going on in the AI domain. So we are not in a very clear position what happens here. All right. So I really don't have the answer. But if you ask me, and if I'm still alive 30 years from now, you probably can come back to my session. You probably can ask me the question. I'll probably be in a better position to answer you. All right. Now, AI has also what we call as bias. Because the data in the and AI machines have been generated in the more developed countries. Okay, AI has been trained. The machine has been trained using data available in these countries. Now, for example, there was a reported case, which is not very. If you are a nation, you won't be happy with this. So there was a reported case where the mission was asked to identify potential terrorist group from a group of people. So they used images of people walking on the road in the US. So being US a cosmopolitan city, they have people from different parts of the world, from South America, from Asia, from Europe, whoever. So the system, because of the data that it was used to train, the system identified whites as non-terrorist group and non-whites, including Asian, to be potential terrorist group. Okay. Similarly, if you are creating AI machines in UKM, you're going to have this issue also. Don't blame the US for this. Yeah, you're going to have the same issue if you use the local data, something from Malaysia, and you are actually asking that machine to identify potential terrorist group. Don't be surprised if your system identify the Americans to be the terrorist group. Okay, so AI will always have its own biasness. Okay, so you have to have a clear idea. If you're doing research, you have to have a clear idea what is AI biasness. You can also use AI to create deepfake videos. Okay, deepfake videos, the name can be a bit misleading, the word fake. When you talk about deepfake videos, in my company, we have an AI company called RoboMind. In AI company, we create deepfake videos for celebrities. All right, just look at this situation. Yeah, if you are a celebrity, if you are Siti Nurhaliza, for example, okay, or if you are Ronaldo, okay. Now you want to promote your brand. Number one, you want to promote products that you are endorsing. Okay, if obviously Ronaldo doesn't speak BM Malay. Obviously, Siti Nurhaliza doesn't speak Spanish. Just imagine you have a situation that you have a video in different languages that Siti Nurhaliza is promoting a brand in Spanish and Portuguese and whatever other languages, and Ronaldo promoting products in Malay and in Japanese and whatever. And if that video is endorsed by the celebrities, so-called celebrities, technically it's not a wrong thing. But deepfake is actually becoming an issue because deepfake videos are created by parties without the endorsement of that particular celebrity. Some of you may have heard about this situation in India. There's a very famous celebrity movie star called Kapoor. What Kapoor is that? I can't recall his name. Very senior actor. There was a deepfake of video promoting a particular brand. He went to court. He sued the company for using a deepfake video. One of the Kapoor family. Okay, there was a deepfake video in Indonesia during the last presidential election that they actually used a celebrity to comment on a particular candidate's weaknesses, and that was not endorsed by that person. Yeah. So deepfake video, if you are using rightly, is actually a good platform. If you are using it, and unfortunately, more often than not, deepfake videos are being used without endorsement. Hence, you have situation like tomorrow, suddenly we have a deepfake video of Cik Izaida, for example, talking badly about Inovasi. Just imagine that happen. Okay, Cik Izaida may lose her job for something that she didn't do at all. And as I said, deepfake video, while 10 years ago it looks a bit odd, you can see the huge difference between the real one and the new one. The genuine one. The current deepfake videos are getting smarter, much better quality. So very difficult to find the differences between the original and the deepfake videos. Yeah. Of course, misuse of invention. You're going to claim inventions that not created by you. You're going to claim invention that people use for a good reason, for different reasons. For example, if let's say you work with something and you created a microorganism, for example, that can be used to treat dengue. Yeah, but the same microorganism AI machine learning can look at your data, can propose to another researcher to say that, hey, can we develop a biological weapon? Okay, it's a very scary thing, yeah. So if you, I think one of you mentioned about if it's a good thing, it's a good thing. Definitely, if you train it to do good things, definitely it's a good thing. If you train it to do bad things, definitely it's going to create havoc in this world. Okay, of course, creativity and IP ownership is always an issue. Like I mentioned, is it your work? Is it your creative work? Therefore, can you claim IP? Or is it not your work and therefore you cannot claim IP? The ball is in your court. I'm not going to say you should do it or you shouldn't do it, but I'm putting you in a position to decide, for UKM to decide what you want to do. Your researchers should follow the guidance of UKM. You cannot have different rules for different parties for the sake of having a policy. Yeah, so keep that in mind. Okay, how do you sell products? Okay, the same issue. If you don't own the IP ownership of the product, how can you sell AI generated products, AI generated services? Okay, can you enter into a contract to sell? Like for example, I mentioned if AI is the owner, AI should sign the contract. Like for example, I'm buying, let's say a pen from you, and AI, so happen the pen was created by AI. Technically, my contract, the sales and purchase agreement, I mean, I'm talking about pen on a very simple manner, yeah. My contract with that with the seller is actually with the AI machine. So if let's say I receive the pen and so happened that I ordered a red pen and I receive a blue pen, who do I claim the losses from? Okay, if your house design was created by machine, okay, or built by machine, for example, okay, not yet, but it will happen in the next 10, 20, 25 years from now. AI going to create, going to build houses. Who do I sue? Okay, so can others copy? Of course they can copy, because if you don't have patents, if you don't have copyright, if you don't have design, okay, technically nobody has any IP rights over that particular product, over that particular services. Therefore, everybody can copy you in that particular jurisdiction. So AI and commercialization will be a major issue in the near future. Okay, now let's look at this particular diagram. Okay, this is actually a very first AI case in China. Okay, I'm sure all of you know Ultraman. Okay, the photo on the top end of the diagram. Yeah, that is the copyrighted work at issue. But if you see the 6 following diagrams, photos, yeah, all those 6 were created by AI. Do you agree that the AI generated images are similar with the original Ultraman? Can someone, all of you, put the comments in the chat? Yes or no? Do you agree they are the same or they are very different? They look the same, Umi said. Same. Yes. Same. Now, this is very interesting because suddenly, for the very first time in the world, we have a copyright case involving AI generated images. This happened in Guangzhou. Yeah? And interesting in China is a very, very interesting country, not because it's a copycat country. Yeah? Don't get me wrong. If you ask me, China is being a forefront in in IP. So they are actually setting up a lot of systems in place to eliminate the stigma being a copycat country. Yeah? So this happened in February this year, very hot from press. And because they wanted to be in the forefront, they have this thing called Internet Court. Can you imagine? That court only handles internet cases. Okay, very interesting situation. No other countries have that kind of a situation yet. So the Guangzhou Internet Court found that generative AI service provider. So here is the service provider, not the creator. Okay, because this is an internet court. Yeah. So the generative AI service provider liable for copyright infringement, and this happened on 8th of February. While contentious AI issues are growing globally, this was the China's first judgment concerning copyright infringement involving AI generated. Okay, so if you see here, the what is interesting is that this copyright case was not between the creator of the images, because it is a machine. So remember I said, if a machine can be the owner, then they have the rights, they should have the rights to sue or get sued, right? So in this case, because the machine, the images were created by the machine, technically the owner of the copyright of Ultraman, the original Ultraman, cannot sue the machine. So what they did was they sued the service provider. That means the internet service provider for allowing these images to be published online. Okay, so most of you probably know Ultraman is actually originated from Japan. So for those who are never knew this, latest info for you is Japanese thing, yeah. But I'm sure almost all of you will know that. Okay, especially for those who are senior, probably watch Ultraman when you are young, you will know it's a Japanese thing. Now, in this case, the person who sued, or the company that sued the internet service provider, was a Shanghai company. Why? Because they own the copyright in China. They acquired the copyright from Japan, from the original Japanese company to the Chinese company, and they sued the internet service provider, and the court said that it was an infringement. So overall, the court said that any rights of reproduction, meaning if, let's say, somebody wants to reproduce images that look like Ultraman, that must be obtained, the rights must be obtained from the Shanghai-based company. Okay, just because your Ultraman images generated by AI does not look identical, okay, of course they don't look identical, but if there's a confusion in the market, like most of you said, yes, same, right? So if consumers look at the images and they think that, oh, this must be variations of original Ultraman, technically that becomes the copyright of that particular Shanghai company, and therefore the internet service provider was held to be liable, and they were imposed some fine, okay, and they were asked to take down all images published in that particular websites, okay, that is being managed by that internet service provider. All right, so my point here is that while you can sue currently, while you can sue, you may not be able to sue the machine. I mean, it doesn't make sense to sue a machine, okay. You need to look at other potential parties to sue. So one of the targets will be, if it's available online, then obviously the internet service providers. If you're publishing on a, let's say, printed copy, then the person who publish the book, like for example, if I publish these images, technically me on my personal capacity or my company should be sued for using that material. Okay, at this point of time, I'm going to take some comments. Let's see whether anything that I can answer. Okay, so Cik Umi asked a very good question at 11:15. I think, yeah, about 20 minutes ago. If the machine can be sued, what will be the responsibility of the creator? Nothing, because when you sue the owner. The creator is pure, the inventor, or in the case of patent or author or whatever, right? So definitely that is not their liability, their responsibility, because they created a machine for one particular purpose, to create inventions. Okay, like for example, Dr. Tyler. Now, if let's say Debus was named as the owner, they started selling the machine, started selling the product, machine started suing people for infringement. You want to counter sue, or you want to sue the machine, technically your target person is not Dr. Tyler. Your target person or entity is the machine. Okay, yeah, it looks a bit vague when I say I have a sue machine. Who is this machine? What is the form, right? That is the issue that we are facing now. So technically, if machines are liable to be sued or can sue or liable to be sued, it will not involve the creators. Okay, at the most, the creators will be brought into the suit as an interested party. Okay, interested party in the legal term means they will be summoned to court to give comments on how they created the machines and what is the purpose of the machine, so on and so forth. So they will going to give you a background information about the machine, but to be held liable, the answer will be definitely a no. Okay, so Sufail said, what happens if they are using only for a joke and entertainment purposes like Mad Lib or parody? This will fall under the fair use, fair dealing category, criticism. So that's why I mentioned about memes, parody also. All these are considered to be fair dealing, fair practices under the Malaysian law and fair use. Hence the reason why you see a lot of parody songs. Like, for example, the very famous song now, Alamak song. I heard somewhere, I don't know whether this is true or not. I heard from a very good friend of mine yesterday that song was created during COVID. Okay, I haven't done research to confirm that yet. And apparently they were not able to publish, the group was not able to publish the song back then. And they only made it available during the recent riot. And all of a sudden that song became so famous that you have parody songs in Japan, in India, and so many other countries. I know in Malaysia, I think last I checked was 20 million views. I'm pretty sure in Malaysia, at least 1,000 videos are there using the parody of Alamak song. Okay, so parodies are allowable under the fair dealing, fair practice, fair use thing. There must be a disclaimer. No. All you have to do is that you have to give a credit, for example. All right. So what normally people do is that the meme creators, the parody makers always highlight in their comment section or in their description section that this song is a parody of so and so. So they don't need to get a permission. It's more like to give credit to the owner, the original author. Okay, so Umi again asks, what if the AI generated images are not copyrighted, but they are printed on the merchandise like T-shirts and etc. You see, copyright does not require registration here, Umi. You must remember that, yeah. Now, why I say that is because copyright is automatic. The moment you create an original work, you will get copyright protection immediately. Malaysia is a member of what we call the Berne Convention, BERNE. Under the Berne Convention, if you create an original work, your work will be copyrighted in all Berne member states, all the member countries. So technically, like for example, in my PowerPoint slide, my material cannot be copied, say in China, cannot be copied in US, cannot copied in Europe, cannot be copied in say Japan, because these are all Berne member countries. But if you ask me, can it be copied in Myanmar? The answer is probably yes, because Myanmar is not a member of the Berne Convention. Okay, so whether or not you register, it doesn't matter. If you claim copyright ownership, technically, let's say you claim copyright ownership on a particular, say this Ultraman image, for example. If I produce T-shirt or any merchandise or any pen or anything mass produced to be sold to customers, technically, you need to sue. You need to sue me because you are the copyright owner. Okay. Now, how do I use the copyright? It doesn't matter. If my material carries your image, your copyrighted material, I'm liable. That's all. But only if you can prove you're the owner, yeah? So don't forget that you must prove that you're the owner. Right? Let's go next. Okay. So now let's come to the legal side. When you talk about we have another 20 minutes here. When you talk about the legal side, Europe has recently adopted a new AI regulation that is actually going to affect the way we sell, communicate, talk to people using AI system. Okay, the very first part that you must remember is that they have given a list of prohibited systems. So this is the definition. Yeah, I'm not going to go into detail, but one of the things that you may be interested to look into is that look at point number 4. Enable facial recognition using web scraping. Okay, so this is a very important, especially in the research arena. Even number 5 also, yeah, the real-time biometric identification. Okay, now if you are creating any system that utilizes facial recognition, that you scrape the web for images, okay, that is a prohibited system under the EU regulation. If you are using biometric identification, for example, let's say you are creating a system to monitor traffic in a particular location. Like say, for example, in UKM, you are creating a biometric system that actually monitor movement of people, say in your cafeteria. During lunchtime, you want to see how you can reprogram your lunchtime so that you don't have a very congested cafeteria. Okay, so you're going to use real-time biometric identification. Okay, in Malaysia, because we don't have a proper guideline, that still will be allowable. But in Europe, that is not allowable unless you are an enforcement agency. Even that also is purely in a very limited situation, right? So EU being EU, they are very kiasu people. Okay, I'm sure the US will follow suit. Rest of the world will follow suit. Maybe in the next 2-3 years, we will see the same regulation will be introduced in Malaysia also. Don't be surprised if that happens. What is happening now is that they want to protect the what they call person's rights. You don't want to be pictured. You don't want to have your picture to be analyzed, to be what they call that, documented for research purposes. That's going to have a lot of implication on you, because you may not be allowed to conduct research. You may not be able to come up with patents. You may not be able to even sell your products. Okay, that will fall under the prohibited system list. Okay, so the question that you need to ask yourself is that, does the regulation actually setting the new way forward for the rest of the world, or is it slowing down the adoption of new technology? We call it the disruptive technologies. Okay, the question that you need to ask. For me, it is a 50-50 situation, because again, I cannot answer for sure, because we haven't seen this being applied clearly. So definitely it will affect the way people talk to each other. Definitely affects the way you do conduct research. Definitely disturbs the new adoptions of new technologies. But at the same time, I can also understand why the regulation has to be imposed, so that the rights of the citizen, the livelihood of the citizen, the safety of the citizen, are not jeopardized. Because I can do whatever I want with the data that I'm getting from the internet, for example, or the data I'm getting from my CCTV camera, for example. So all that has to be properly considered as well. So it's going to affect us, no doubt. At the same time, I can see why it is important. Okay, so now the question to you that you need to ask yourself, being a Malaysian university, being companies located in Malaysia, what will happen to Malaysia? Will Malaysia follow suit? Definitely. So can we invent the so-called prohibited system? The answer is yes, you can. Okay, until the regulation, the EU regulation is regulated in Malaysia. That means you can continue inventing something, you can continue selling something that probably fall under the prohibited list or system list, but the moment the rules come in, the regulation come into force, you may be barred from doing so. So when you are doing research now and you think that your systems will fall under the prohibited system list, you have to be careful, because your system probably will take another 2, 3, 4, 5 years to be commercialized. What happens if by the time the regulation is introduced in Malaysia, you're going to be caught all of a sudden? Yeah. So please keep that in mind, that Malaysia will follow suit. I'm not proposing they will or they may. I'm telling you it will happen. Okay. Now, can we claim IP ownership in Malaysia? Yes, you can. In Europe, yes, you can. But can you sell? The answer is no. You can file patent. patent will not, the patent officers will not consider whether you are allowed to sell or not. The patent officers will not consider the prohibited system list when it comes to considering patentable inventions or not. But when you want to start selling your products, you're offering your services, then you're going to have problems because nobody will buy from you, or even if they buy, they're going to fall into the risk of getting sued by the regulatory, the authorities in Europe. Okay, or even in when it is imposed in Malaysia, you're going to have problem with the Malaysian authorities also. Okay, what will happen in other countries? Sooner or later, all the countries will start putting up these kind of systems, this kind of regulation in place. So be careful. AI, while the name sounds very sexy, very interesting, I foresee a lot of problems, especially if you are doing something that may fall under that particular prohibited system list here. So be very, very careful. Okay, now we are talking about future in AI in Malaysia. Budget 2024, probably some of you may have heard that they have allocated a 20 million ringgit budget to set up a first AI faculty in UTM, KL, I think, KL campus. Now, this is going to be the future AI, okay? Currently, the faculty or the research is part of Cairo UTM, but eventually they're going to have a first fully dedicated AI faculty in Malaysia, in UTM, yeah, number one. Number two, I'm pretty sure UCAM will be working on similar concepts, similar systems in place, unless you already work on it, okay? If you ask me what is Cairo stands for Center for AI and Robotics, okay? So now, I mentioned about KL20. So for those who are following the news about KL20 that is happening now, you will see a lot of discussion about AI setting up new integrated design, circuit design in Selangor and all that. So AI going to be in the forefront. So hopefully, I'm quite confident with that. We will have a very strong presence in the semiconductor domain. In other AI research area, I still have my thoughts about it. But semiconductor, because we have a 50-year history in the semiconductor industry, I'm quite confident that we will have a very strong say in this domain. Now, before I go to the last part, the case study, let me take some questions or comments in the chat. Oh, just thank you. Okay, thank you, everyone. Okay, now, Roboma is a company owned by Edipman, my IP firm. Okay, so now this and they are actually an R&D firm specializing in AI. Let's look at this case study here. Roboma is in Setapak, so fully like a Malaysian company. Of course, we engage expatriates to work with us. We also have local talents to work with us. We also welcome students to intern with us. Okay, so open invitation to all of you and to the lecturers. If you have any students thinking of doing internship, we welcome them. Not necessarily must be from computer science or engineering background, even mathematics, statistics, because we need data scientists. We also welcome people from different domains, like for example, medical or even what do you call that, sciences. We welcome them because we need different use cases experts here. Now let's look at the first case study, Oud.ai. Oud, for those who are familiar with the Arabic term Oud, it actually means, correct me if I'm wrong, Oud means something that is interesting, something that is nice, something that is futuristic, something unique. Yeah. So that is what do you call that? The background story about why we came up with this platform called Oud.ai. Oud.ai is actually a platform where you create inventions using the platform. So what you are doing is that let's say if you are a researcher, if you're a student, if you're a lecturer, you have a case study. For example, I want to create a solution whereby I want to check whether my student assignments are actually copied from generative AI platforms like ChatGPT. Or you want to create a platform or AI solution that can see whether how do I predict chances of people getting diabetes. Okay, so Oud.ai is actually a platform where you can create AI solution simply like using like Google. So you put in the data, okay? Let's say, for example, let's say you have a 1 year data of people having diabetes, age group, say 20 to 40, for example, okay? You have the sex, male, female, you have their occupations, for example, you have other parameters. You can put in the data into U.AI. The system will create an app, for example, AI solution that can predict, let's say in the future, someone fall within that criteria, what are the likelihoods of that person being a diabetic patient or non-diabetic. Okay, very simple, very interesting platform. This is not very unique if you ask me, because there are similar platforms, but what is unique about U.AI is that it's actually 100% Malaysian owned. Okay, there are other platforms like this, but they are all foreign owned platforms. We are the first in Malaysia who come up with this kind of platforms here. So some of the use cases that we have tried is that, for example, for those like say doing food truck business, they want to know where should I park my food truck today, so that I can maximize the sales, minimize my wastage. For example, if I park my food truck in Bangi, the system, you can ask a question to U.AI, to the solution that created by U.AI. Should I park my food truck in Bangi or in Bangsa where Rama is, for example? Okay. Now, the system will look at all the parameters like weather, like holidays, like say strike, for example, or other parameters, right? And the system will suggest to you, today, if you sell 100 nasi lemak in Bangi, you can sell 90 pieces. But if you make 100 nasi lemak today, you probably can sell 100 pieces in Bangsa. Okay. If you sell nasi lemak in Bangsa, you can sell for 2 ringgit, but in Bangi, you probably have to sell for 150 only, for example. So all this recommendation can be provided by the solution. And therefore, as a food truck owner, you have like a bird's eye view of what to do with the recommendation. Remember, the system will not tell you go to Bangsa, period. No, the system will tell you, if you go to Bangsa, this is what will happen, pros and cons. If you go to Bangi, this is what will happen, pros and cons. The decision is still with the food truck owner. Okay. Similarly, we have how much stock I have. That's the second part of the use case. How much item I should sell today. What routes I should take if I'm doing Grab, for example. Okay. If you are talking about a research perspective, what will be the platform, what will be the solution to make sure that my product is patentable? How do I make sure that my product is comparable with other existing products in terms of price, in terms of the output, etc., etc. All those things, from the very simple case study use case to a very complicated use case, is possible to be done through U.AI. Right? Okay. So it's 5 minutes before 12. So I think I added just on the dot. So I'm more than happy to take any question. If the time taken is beyond 12 p.m., I'm still okay to continue the discussion. With that, Cik Najwa, I return back to you for the Q&A session. Thank you, Cik Najwa. Thank you, everyone.
Okey, kepada peserta yang ingin bertanyakan sebarang soalan, boleh terus buka mic untuk tanya terus kepada penceramah.
Yeah. Also, if you want to put in the chat, I'm okay also. But if you want to ask live, yes, please switch on your mic. And please identify yourself so that people know who you are. And also, please don't share anything confidential, yeah? Because there are about 167 people here today. So we don't want your confidential information to be leaked out just like that, yeah? So I see something in the chat. Okay. You're most welcome, Suhail.
Okay, kita
Thank you,
beri
everyone.
masa
Thank you.
dalam beberapa minit
Yeah,
untuk para peserta nak berfikirkan soalan.
Sure. Kita ada sampai pukul 12, so kita ada masa lagi.
Okay. Mohon para peserta untuk tunggu sebentar dahulu sebab kita akan ke sesi yang seterusnya, iaitu sesi bergambar, dan juga nanti kita akan paparkan link kehadiran. Okey, sekiranya tiada soalan, mungkin kita boleh tutup sesi ini. Right, terima kasih Encik Ramakrishna. Perkongsian yang amat menarik dan sedikit sebanyak telah membuka minda kita semua dalam meneroka peluang yang ada dalam antara teknologi AI dan juga harta intelek yang boleh membawa inovasi yang bermakna di dalam kehidupan dan seluruh masyarakat. Akhir kata, marilah kita terus berusaha menjadi ejen perubahan positif dalam dunia yang semakin canggih ini. Selamat maju jaya kepada semua peserta di sini.